Hello, AP exam test takers. Mr. Adams here. I'm going to do a quick video that gives you the 15 Supreme Court cases you need to know for Monday's AP exam. So I'll go pretty fast. I'm going to be very concise, but make sure you know about these. Make sure you read up in the PowerPoints and in the review packet as well. Okay, so let's get through these 15 really fast. Number one, Marbury versus Madison, 1803. It establishes judicial review. It asks the question of Article 3, is the power for the court to issue a writ of mandamus in the Constitution? In fact, it is not, and that's why the Judiciary Act of 1789 is ruled unconstitutional. So that establishes judicial review, 1803 by John Marshall. Next case, also by John Marshall, 1819, McCulloch versus Maryland, probably the most important case in the entire history of the AP government exam. It deals with the relationship between the national and the state governments. It decides once and for all that the national government is supreme. It relies upon the supremacy clause to do that. It uses Hamilton's notion of implied powers to say that there are things that the federal government can do, even if they're not enumerated, even if they're just implied. And it dealt with the constitutionality of the Bank of the United States and actually upheld the constitutionality of that institution. Number three, Brown versus the Board of Education, most important case of the 20th century, 1954, rolls back and reverses Plessy versus Ferguson. It deals with the Equal Protection Clause of the 14th Amendment and says that separate is inherently unequal and that schools need to begin desegregating with all deliberate speed, and that segregation violates the Equal Protection Clause of the 14th Amendment. Next, Gideon versus Wainwright, an important 1963 case dealing with the 6th Amendment and the right to counsel. Gideon petitioned the court himself, and the Supreme Court said that all states and all localities have to provide for a not just an attorney, but representation from the public defender's office if somebody who is accused of a crime cannot afford one. Next, Tinker versus the Des Moines School District deals with the First Amendment. It deals with what we call symbolic speech, which is speech that makes a point without saying or writing anything. It also deals with student free speech, and it dealt with two students, the Tinkers. Mary Beth and John Tinker wanted to wear these black armbands to protest the Vietnam War. The Des Moines School District said they can't. It went all the way to the court in the 1960s. It's the Warren Court, so the individual is going to win out there. Next, Roe v. Wade, 1973. I know that sounds like it's an abortion case. It really is about a right to privacy. It's an extension of the 1965 case Griswold versus Connecticut, which was the first one to establish a general right to privacy under the idea that there are rights in the Constitution that are not necessarily listed, because that's what the Ninth Amendment says. The Ninth Amendment is about privacy. It's about unenumerated rights. And Roe v. Wade in 1973 was just an extension of the right to privacy to include the first trimester of a woman's pregnancy. Next, U.S. versus Lopez, 1995. This is a great example of the Supreme Court pushing back against the power of the federal government, giving more power to the states. Essentially what it did was it said that a law that was limiting the power to hold guns within a certain number of feet of a school is unconstitutional. It says that the Commerce Clause does not have the power to legislate on that. Next, New York Times Company versus U.S. This is what we call the famous Pentagon Papers case. This deals with prior restraint and the idea that the government can stop you from printing or saying something before you say or print it. And of course, the court sided with New York Times. It sided with the Washington Post, and it said that if the government's going to censor you, it has to reach a very high standard of national security to do so. Next, Baker versus Carr, also related to Westbury versus Sanders. This is about malapportionment and the idea that when you draw congressional districts every 10 years, malapportionment is when you have unequal numbers. This said that violates the 14th Amendment and equal protection. So every district in America has to have roughly the same population. Engel versus Vitale, 1962. This deals with freedom of religion, specifically the Establishment Clause and school-led prayer. Remember, the Supreme Court said that the government cannot be biased in any way for or against religion or one religion over another, and that essentially if the New York school district, if schools in New York cannot lead students in prayer in a public setting, right? Now, students can pray themselves all they want, but it can't be a school-led prayer. Wisconsin versus Yoder is not an establishment clause. It is a free exercise case dealing with the fact that the Amish don't go to school past 8th grade. Most states say that you have to go to school through the age of 16. There was a clash. The Supreme Court sided with the Amish because they said they were clearly freely exercising their religion. 13, McDonald versus Chicago, very important case dealing with the Second Amendment, the right to bear arms. The reason why this is important is it is an incorporation case. Places like Chicago and Washington, D.C. could, virtually eliminate firearms because the Second Amendment was not incorporated until 2010. Almost 50 years had gone by between incorporation cases. 14, Shaw versus Reno also deals with gerrymandering. Specifically, it dealt with a district that had been drawn in North Carolina, where certain litigants had said that they only drew it according to race. And Shaw versus Reno said, minority majority districts, you can't just look at race. You have to look at other things as well. And finally, Citizens United versus the FEC says that unions and corporations have a free speech right. Okay, hope that helps. Good luck, everybody.